Welcome back to our channel. Now we will discuss on section 12A of IBC. Can a company escape insolvency after the process has already started? This is the question. What if the promoter wants to take back the control? This is whether 12A of Insolvency and Bankruptcy Code comes in. Whether section 12A of IBC game changer or legal hurdle. In this video, we will break down what about section 12A of IBC and how it allows the companies to withdraw from insolvency. Why does that 90% of COC approval matters? Real life case studies and NCLT judgments. If you are a business owner, insolvency professional, or curious about corporate law, stick around, let's dive in. What is section 12A? Imagine a company enters in insolvency, but suddenly the promoters manage to arrange funds. Can they withdraw from insolvency? The answer is yes. But which conditions? But with the conditions, what conditions? Section 12A of IBC allows for withdrawal of insolvency proceedings if the applicant who filed the insolvency case wants to withdraw it. The Committee of Creditors, COC, approves with 90% of voting in favor. The National Company Law Tribunal grants final approval. Company X admitted into insolvency. But within months, the promoter secure funding and request withdrawal under section 12A. If 90% of creditors agree, the case is closed. But why was this provision introduced? Let's look at its origins. Why was section 12A introduced? Section 12A wasn't always part of IBC. It was added in 2018 to prevent unnecessary insolvencies and allow genuine promoter to chance to review their companies. We'll go to case law. Uttara Foods and Feeds versus Mona Pharmachem. Supreme Court ruled that insolvency cases could be withdrawn if both the parties agreed. This led to Section 12A being introduced to formalize this withdrawal process. So what is the catch? Let us talk about the biggest hurdle, COC approval. 90% COC approval requirement. Getting 90% creditors to agree is not easy. Here is why. The reason is creditors may prefer resolution over withdrawal. If an alternate bidder exists, creditors might not approve withdrawal. Legal delays, NCLT and appeals can slow down the process. The case law, Sanjeev Mahajan versus Nehru Place. Sanjeev Mahajan versus Nehru Place Hotels in 2024. NCLT ruled that once a resolution plan is approved, Section 12A withdrawal is no longer allowed. This ensures that once the process reaches an advanced stage, it cannot be reversed easily. But what if a promoter is banned from taking back the company? That is where Section 29A comes in. Section 29A, who cannot use Section 12A? See, Section 21, 29A of IBC bars certain people from submitting a resolution plan. But does it also apply to 12A? Who is ineligible under Section 12A? Promoters of defaulting companies, willful defaulters, convicted individuals, disqualified directors are ineligible under Section 29A. However, MSMEs get an exemption. If a company is in micro, small, or medium enterprise, Section 29A, Section 29A restriction does not apply. Maharashtra Seamless versus Padmanabh Venkatesh. Honorable NCLT ruled that once a resolution plan is submitted and approved by COC, a resolution applicant cannot withdraw under Section 12A. So if withdrawal isn't possible, what other options exist? Let's explore other options. Alternatives to Section 12A, how can promoter save their company? See, promoter want to regain control, they should act before insolvency starts. Here are some options. Debt restructuring with banks, settle dues before insolvency begins. One-time settlements are there. Negotiate a partial payment with banks. Compromise agreements, get creditors to agree on repayment plan. Appealing to NCLT for more time. Some cases allow extra time before insolvency starts. Now let's look at how courts have ruled on major Section 12A cases. Landmark case studies on Section 12A. Pratham Expofab versus Anil Matta. COC rejected the promoter's second Section 12A request. The NCLT ruled in favor of successful resolution applicant SRA. Here the takeaways as multiple withdrawal attempts won't work once COC approves a resolution plan. And case number 2, Hind Motors India Limited. Honorable NCLT ruled that NCA Section 12A cannot be used during liquidation. See, once liquidation starts, withdrawal is not an option. So when does Section 12A actually works? Let's conclude with the key takeaways. Final thoughts, key takeaways. Section 12A allows withdrawal from insolvency, but only if 90% creditors agree. Once a resolution plan is approved, withdrawal is not allowed. Promoters must act early. Debt restructuring and settlement are better options. NCLT rulings favor resolution over withdrawal, so timing is the key. If you found this video helpful, don't forget to like, share, and subscribe for more insights and insolvency law. Thank you.